Lūdzu visiem piecelties, tiesa nāk.
Please rise, the court is coming. Good morning. Please take your seats. The solemn hearing of the Constitutional Court of the 3rd February 2023, dedicated to the opening of the new judicial year, is declared open. The participants are President Aldis Laviņš, Justices Irēna Kuciņa, Mr. Neimanis, Artūrs Kočs, Anita Rodiņa, and Hans Neimanis. Dear ladies and gentlemen, the report about the development of constitutional law in Latvia in 2022 will be given by President of the Constitutional Court, Mr. Laviņš. Excellencies, ladies and gentlemen, esteemed participants, the new year of the Constitutional Court for the 5th time is opened by a solemn hearing during which the Constitutional Court is reporting to all inhabitants of Latvia about achievements of the previous year and the plans for the coming year. Holding of the opening hearing for the judicial year is very important because at a democratic state governed by the rule of law, such annual report on the work of the Constitutional Court creates a direct link with sovereign, the people of Latvia, and also reinforces legitimacy of the court's work. The people of Latvia, through democratically elected parliament, has established the Constitutional Court for itself to ensure protection of the constitutional order and fundamental rights of everyone. It is notable that today, for the first time, we are holding this solemn hearing in a year when Latvia is already entering the 2nd century of our basic law, the Satversme. When reporting on the development of constitutional law in Latvia in 2022, I will highlight the immense amount of work done in the previous year. We have worked intensively with the cases that we have been reviewing. We have praised our constitution on its centenary. We have reinforced the judicial dialogue with society, with Latvian and international institutions, and have ensured continuity of the court's work while saving energy resources. And we have constantly provided support to our colleagues at the Ukrainian Constitutional Court when the Ukrainian people are fighting for their freedom. I would like to thank from the bottom of my heart all justices of the Constitutional Court, their assistants, the legal department, court administration, structural units, all my advisors and the court employees for all the achievements of the previous year, both in terms of the court's work and in interinstitutional and international cooperation. Thank you, dear colleagues. The Constitutional Court has certain responsibilities and obligations vis-à-vis society. One of them is, in the framework of a dialogue, to bring the rule of law closer to every person. And I will continue by discussing how the Constitutional Court is discharging this obligation. I will start by discussing quantitative results of 2022, and then I will speak about the most valuable findings which are important in ensuring justice. Briefly about statistics. In 2022, in general, 44 cases have been initiated at the Constitutional Court. Similarly to the previous years, the largest number of the cases have been initiated on the basis of constitutional complaints of private persons, 33. 3 cases have been initiated on the basis of courts applications. All the courts have been administrative courts. 5 cases on the basis of applications by municipal councils, and 3 cases on the basis of applications by no less than 20 members of the parliament. We see an interesting trend that a large part of the submitted applications and the cases are related to different criminal procedural issues. Norms of criminal procedure law have been contested in every force of the applications, and mainly these are pertaining to proceeds of crime. In connection with these cases, we have to note that quite recently the Constitutional Court made 2 decisions on referring questions for preliminary rulings to the Court of Justice of the European Union regarding access to case materials and also appealing of the court rulings. Last year, the compliance of 42 legal norms with the Constitution have been examined. 16 legal provisions were recognized as being compatible with the Constitution, but 26 legal norms as being incompatible. Most often, the contested norms have been recognized as being incompatible with Article 105 of the Constitution, which guarantees a fundamental right to property, and Article 92, which defines the right to a fair trial. Now, speaking about the content of the court's work. The Constitutional Court, in its case law in 2022, has reached several important findings which reinforce the rule of law and should be taken into consideration also in creating law. I would like to highlight some of these. In the area of taxes, the Constitutional Court emphasized that fair taxation policy encourages taxpayers to pay taxes voluntarily, and the court recognized that the law on income tax is based on the possibility of taxpayers to pay a tax, whereas the contested norms allowed a situation where the tax had to be paid also in the absence of revenue. And the Constitutional Court held that it was contrary to the principle of justice and legal equality. A case regarding mandatory purchase and the requirements set for biogas power plants was important for the sustainability of Latvian environment. The court recognized that the possibilities of the present generation and the future generation to live in benevolent environment depended upon the state's possibility to implement sustainable development, protecting the global climate system by preventing or neutralizing causes of climate change and decreasing their harmful effect. Energy efficiency, which includes also proper use of heat energy, is one of the tools for reaching climate aims. During the previous year, the Latvian society was slowly recovering from the difficulties caused by COVID-19 pandemic. And the cases related to restrictions that were imposed to curb the spread of infection were examined in all our judicial institutions, also by the Constitutional Court. In the so-called shopping mall COVID case, our court has specified the precautionary principle, indicating that in the case of uncertainty and when immediate action is needed, the state institution should not wait for the moment when actual damage sets in. Those issuing legal acts may choose from several alternatives the one who would ensure with higher degree of probability protection of persons' rights and interests and society's rights and interests. But this institution has to examine the alternatives. In the so-called distance learning case, the Constitutional Court did not permit a narrow and formal view on these unprecedented circumstances of pandemics. The fact that emergency state has not been declared in the state does not mean that the state should not act urgently to prevent threats to persons' health and well-being. On the one hand, the state has to fulfill its obligation to protect human health. On the other hand, the state also has obligations following from the right to education, and this right has to be exercised also in circumstances when infection is spreading. In such circumstances, the actions of the state by imposing restrictions on fundamental rights, the opinions of specialists and experts has become more relevant. And this finding is very important also for the legislator when creating new laws. Now, the next case. The Constitutional Court in its case law has highlighted in particular the significance of the state of the official language as an element of constitutional identity. Also, the European Court of the Court of Justice of the European Union, when providing preliminary ruling regarding provisions of the law on institutions of higher education, stated that the obligation to implement study programs only in the official language of the state was not incompatible with EU law, especially if this legal regulation is justified by considerations linked to the protection of national identity, if these provisions are necessary for reaching the legitimate aim and disproportional to it. This means that restrictions are possible. However, the national courts have to examine their proportionality vis-à-vis the legitimate aim. And finally, in the case in which legal norms that regulated confiscation of the proceeds of crime were examined, the Constitutional Court emphasized that confiscation of the proceeds of crime is implemented with the aim to guarantee the principle that crime should not bring fruit. The cases that were initiated in 2022 also provides the grounds for us to consider what kind of new trends of development in the constitutional law we might expect this year. I would like to inform the Latvian society that the following issues will be examined by the Constitutional Court. The amount of the state guaranteed minimum income and the period for reviewing it, acquisition of education only in the official language in private institutions of education, the obligation of a member of parliament to be vaccinated against COVID-19, changes in the model of port governance, obligation of municipalities to pay from their own resources for dismantling of objects praising the Soviet regime, or also the amount of teachers working in preschool education. We will also be examining the right to use land and payment for it, because this institution has replaced the institution of forced land lease. And although the changes have happened, this new regulation nevertheless has been contested at the Constitutional Court. And at the end of this month, the Constitutional Court will start examining the case. Likewise, the Constitutional Court will also examine this year the norms regarding prohibition of gambling included in binding regulations of municipalities, and also we will be examining also the binding regulation on Riga spatial plan. And hopefully the Constitutional Court will also manage to hear the case this year of the related to provisions allowing to decrease the diameter of cutting trees. These cases will be major challenges for the Constitutional Court this year.
Dear ladies and gentlemen, one of the primary tasks of the Constitutional Court is to identify and analyze challenges that are of concern for the Latvian people and try to resolve them within the scope of its competence, while also referring them to the legislator and the executive branch so as to ensure that every person can enjoy their rights and enjoy decent living. This year, we will indeed face new challenges when it comes to analyzing a guaranteed minimum income provided by the state and the review procedures. Thereby, the more recent Constitutional Court judgments with regard to guaranteed minimum income in 2020 specifically stressed the obligations of the government to regularly review the amount of social assistance. At the moment, since these judgments, the world is different. People's needs are influenced by unprecedented factors such as energy availability of the commodity goods, increase of prices that has especially hard hit the socially vulnerable groups, and people who don't enjoy the support of the government are feeling excluded. They don't have the sense of belonging to Latvia, or this sense of belonging has disappeared, which is even worse. There are some social groups who are very weakly aware of their rights and legal protections, and they are educated only through the social services, non-governmental organizations for the support of vulnerable groups. And people in Latvia must also be aware that the Constitutional Court provides legal assistance to those who most need it. Until now, dear colleagues, the government subsidized legal assistance for socially vulnerable groups were used so seldom that we have to ask ourselves whether this good intention, this tool that we have created upon our own initiative, upon the initiative of constitutional courts, it is efficient in protecting more vulnerable groups of society and their rights. Constitutional Court has had a similar judgment in the case of distance learning. The same principles were applied to the right to be forgotten. So the state needs to analyze the risks linked to use of internet, use of technical equipment, and appropriate environment, because if these resources are insufficiently managed, they might lead to discrimination of some of the groups of society, which would set the divide between the court and an individual even further apart. And we will raise these issues as we meet with other constitutional bodies of Latvia. Dear people of Latvia, given the current geopolitical challenges, it is especially important to defend our democracy. Just recently, I participated in the European Court of Human Rights official judicial year opening meeting, and during these discussions, colleagues from the Council of Europe voiced their concerns about the threats to democracy in modern Europe democracy nowadays is not only the rule of majority. Democracy is also aspiring to protect basic rights, the supremacy of law and independence of judiciary. Democracy is not going to survive in a country that is not abiding by the rule of law. That's why the rule of law is our main priority this year. We will need to protect it, and we will need to protect it not only this year, but for many years to come. At a time when we are going through various turbulences as democracy, we must focus on immediate and decisive steps towards creating a favorable environment where minor tweaks in the legislation, seemingly innocent tweaks that are limiting political participation, freedom of speech, and freedom of press might lead to negative consequences for a democratic country. And we also see cases when the independence of the courts is being weakened. Let me just remind you that without professional and independent judiciary, democracy would not be sustainable. That is why we must be very careful when analyzing all kinds of initiatives limiting the independence of the judiciary. For example, the appointment of the Judicial Council members, shorter mandate of judges, and disciplinary penalties for judges, and so on and so forth, must be very carefully scrutinized in order to avoid covert attempts to dismantle the democracy. If we fail to notice these signs well in advance, we might regret it later. Dear colleagues, as we promote the independence of the courts, we should avoid creating a branch of judiciary which is closed off, isolated, and only pools the power without allowing the residents that hold the sovereign power to take full part in improving the performance of the court. Any such steps would be harmful for a democracy. We must also take pride in the fact that in Latvia, in our political system, these threats to democracy, apart from the idea of shutting the Constitutional Court down, which were voiced in the pre-election campaigns, we should also think about reasons why these attempts have never succeeded, attempts to limit democracy and independence of the judiciary. It means that the political culture and the understanding of the division of power has increased in Latvia. So it seems that that's what I wish to our country. And the experience or the concerns voiced by some of the European Union member states show that not everyone in Europe thinks the same way, and that is why it is very important to maintain international dialogue. Through such dialogue, Constitutional Court judges can access directly information, knowledge, and expertise of other countries, also on the risks or threats to the proper functioning of democratic states. We must remember that a situation in our country may improve, or if some factors apply or come into effect, may also weaken, and that is why we must keep our eye on these threats and must continue ensuring, guaranteeing independent courts and the protection of basic rights and freedoms. Dear colleagues, Constitutional Court in 2022 focused on the dialogue as an important vehicle for promoting cooperation with all potential stakeholders. The opening meetings, together with annual multi-institutional dialogue, improve the institutional dialogue in Latvia, which is essential for strengthening the rule of law in our country. We also need international dialogue to ensure that the Latvian legal thought is on the map of the European legal debate and world legal debate. Our institution in recent years has focused very closely on international cooperation. That is why, along with the representatives of diplomatic missions and our ambassadors to Latvia, our opening meeting is also attended by our closest international cooperation partners, namely the representatives of the Lithuanian Constitutional Court and its president, Danutė Jočienė. I would like to also underline that Constitutional Court in its everyday work is focusing more extensively on its international image and reputation. Over the years, Court has constantly worked on its image through promoting its international ties, understanding the importance of these international ties to the promotion of the rule of law in Latvia. And internationally, in 2022, we also had major breakthroughs when it comes to international cooperation of Constitutional Court. In October, during the World Constitutional Court conference, our Constitutional Court was approved as on the executive board of the Conference on Constitutional Justice, and we will, in the next 4 years, represent the interests of all the constitutional courts at the world level. Such a mandate, such an honor to the Constitutional Court shows how faithful we've been to the values that we've been defending in our everyday work. International dialogue was specifically important in 2022 when Russia launched a full-scale invasion of Ukraine. Let me be direct. This conference, which focused on justice and social peace, saw many constitutional courts taking very passive position with regard to the Russian Constitutional Court participating and continuing its membership in this organization despite it admitting the occupation of some of the areas of Ukraine. During this conference, we saw that there were compromises sought with the threats to democracy, but we also saw that the Russian attack on an independent Ukraine changed the position of many European countries. We can no longer tolerate any threats or risks to the democracy, contrary to what representatives of other continents claim. This is not merely a political challenge that the courts should have no business with. It is our struggle it is a fight for freedom, for democratic political system. And the Russian Constitutional Court, which has admitted the annexation of the occupied Ukrainian territories, has become a political institution legitimizing the plans of autocratic regime. It is not acceptable according to the international law. In February 2022, some might have thought unusual that by a court of an independent state, a flag of another country may be raised, and that Baltic courts then on everyday basis deal with constitutional challenges at the national level would demand Russian and Belarusian constitutional courts to be expelled from the international constitutional court community. However, in October, together with our Baltic colleagues and a number of other countries, we managed to achieve that the Constitutional Court Constitutional Court of Russia resigned from international organization, and Ukrainian flag continues to fly high by our building as it did from the first days of the war. Given those democratic challenges and threats that I outlined to the international order, I would like to urge everyone to continue supporting Ukraine as it fights for its independence and democracy, because this challenging situation will also continue or will remain after the victory of Ukraine. It is difficult to build a democracy in a country that has been demolished and devastated when you have so many other needs. In this regard, our historic experience, post-war experience, also shows that authoritarian regimes may come to power after the war. That's why we need to work very closely with our Ukrainian partners and partners in other countries that are attempting to become members of the legal space of Europe, to avoid any weakening of democracy and strengthen independence of courts and facilitate their integration in the democratic system of the post-war country. 2023 will be the year when we focus on the agenda of the World Conference on Constitutional Justice. We'll have multilateral discussions with all the other European constitutional courts about the efficient representation of the European courts and their interests at the international level. Starting from May 2023 until mid-November, Latvia, for the second time, will also be chairing the Council of Europe Ministerial Committee, and these serious obligations also entail a very intense meeting and event agenda, and I'm absolutely certain that the Constitutional Court will be able to provide its participation in all of these events. Together with the Supreme Court in Riga, we will also host an international conference devoted to the topic of the role of courts in the ECHR judgment implementation.
And finally, I'd like to emphasize that perhaps the most important element in the dialogue, the Constitutional Court's openness to the Latvian society by implementing diverse and different activities and also the use of contemporary mechanisms of communication addressing diverse groups of society, informing society about fundamental rights and instruments for protecting them, by explaining the scope of articles of the Constitution is the reason why we are now gradually collecting all our findings on each article of Chapter 8 of the Constitution. Last year, we published the second publication in the form of a bookazine on the principle of legal equality. Many of our justices and also employees contributed to reinforcing dialogue between the court and society by being involved in the awareness-raising campaign for school students, MIU and the Constitution. And we were also involved in setting up the exhibition at the National History Museum, Constitution 100+. We have also opened our door during the museum night. And we are also offering a virtual tour of our history room. It's important for us to make everyone feel as being respectfully heard at the Constitutional Court. Our dialogue with society continues to include also children and adolescents. We are organizing the traditional competition of essays and drawings, and this year we held also the first plein air with the Academy of Arts, a story about the Constitution. And the works created during this event really gives us hope that despite the difficulties that we are experiencing today, the future of our state and democracy is in the hands of educated, decisive, and free people. We are also developing our podcast, Tversme, thus expanding knowledge about the values of a democratic state governed by the rule of law, application of the Constitution, and the work of the Constitutional Court in a way that's convenient for everyone in Latvia. At the same time, rule of law, which is brought closer to everyone, does not mean making or presenting the Constitutional Court in a primitive way, or as easy way as possible. No. This goes hand in hand with urge to become more educated, to study more complicated issues of law. It is our aim to make people more knowledgeable about their fundamental rights and also obligations vis-à-vis society. I'm convinced that various forms of dialogue with different bodies of all branches of power and international partners on cooperation, this ensures protection of the sovereign's rights and interests, even if it is not involved directly in some stages of the dialogue, because all state institutions should work in the interests of the Latvian people. To guard our constitutions means serving our people. Humility in our attitude and also vis-a-vis all problematic situations of persons, it's our obligation. It's a message that we have that the representatives of the state power should give to all persons to create the sense of security, satisfaction, affiliation, and social peace. Actually, this is our mission. And it has been defined in a very simple way in our Constitution, because Article 92 really contains this word, everyone. And without this, the Constitutional Court would be unable to guarantee in a due manner protection of the fundamental rights guaranteed in our Constitution. Everyone may defend their rights and lawful interests at a fair trial. And that is the very point of departure, the very basis allowing us to gather here today for this solemn hearing, because the Constitutional Court has been established with one basic aim: to work on behalf of the people of Latvia and on behalf of each individual within it by administering justice within its jurisdiction. And that's why we are open to everyone. Everyone is a value, and we are going to defend the rights of everyone. Thank you. Thank you, President of the Constitutional Court. Dear colleagues, and I'm very honored now to ask our guest of honor of the Constitutional Court, a very close partner in international cooperation of our court, President of the Lithuanian Constitutional Court, Madam Danutė Jočienė, to give her speech on bringing justice to everyone. Please, the floor is yours.
I have to press something, okay. Okay, I will start again. Labryt, Satversmės tiesas prieksėdėtai, tiesneši, dargija kolegė.
Good morning.
The Latvian Constitutional Court, distinguished judges, excellencies, ladies and gentlemen, and dear colleagues and friends. I am very grateful for being invited to speak today in the solemn session for the opening of the judicial year of the Constitutional Court of the Republic of Latvia. I am deeply honored to be the first representative from a foreign country who was entrusted with making a speech at the solemn event. It is wonderful that our personal and professional lives intersect again in this official ceremony, bringing two Baltic states and our common ideas of constitutionalism together in this extremely difficult period in Europe's legal history. I am also proud that during the last 2 years, under my leadership, the Constitutional Court of the Republic of Lithuania has been fostering very close cooperation between our courts and mutual dialogue, and not only among judges, but also among our court staff members. We are ready to welcome Latvian Constitutional Court lawyers delegation in Vilnius in February of this year, and we will take all efforts to ensure that this meeting in Vilnius will be memorable and professionally enriching for you. The long-standing judicial cooperation and friendship between the Latvian and Lithuanian constitutional courts, developed since establishment of the Constitutional Court of Latvia, give us not only the opportunity to meet each other repeatedly, but most importantly, they contribute to professional and personal enrichment. Wide-ranging discussion on various constitutional issues and the judicial experience shared, the mutual cooperation permit us to better tackle the common constitutional challenges about what the President Laviņš was also talking this morning. I am also pleased to note that the relation between the Constitutional Court of Lithuania and Latvia has successfully developed during the years, and I really truly hope that this relation will continue on the same high-level cooperation scale in the future when I leave the court in 1.5 months. And of course, now I will not read anymore. I would like also to congratulate the Latvian Constitutional Court with the very honorable position as a bureau member in the World Conference of Constitutional Justice. And I really think, as mentioned by President Laviņš, that Latvian Constitutional Court will be the best court in protecting in the best way Europe's interest in the World Conference of Constitutional Justice, and also, of course, in protecting Ukraine's interest at this very important world-level forum. So I wish you, the President, the judges of the Constitutional Court, really the best success in the Bureau of the World Conference, because this is very important to all of us. Okay, today I speak about bringing justice to everyone, which reflects the essence of democracy and is closely linked to the fundamental principles of the rule of law, which, as we all know, and as mentioned by President Laviņš, confronts today with many challenges. John Lewis once said, I quote, "We have a right to protest for what is right. That's all we can do. There are people hurting, there are people suffering, so we have an obligation, a mandate to do something." End of quote. In rephrasing the words of John Lewis, the sentence would mean the states, including the judicial system, positive obligation to act in order to bring justice to every person who is in need of protection and support. And in my speech today, I will try to focus on three main aspects, which in my opinion are very important when we are speaking about the right to bring justice to everyone. The first aspect is the duty of the judge to perform the proper and reasonable balancing of interests involved in the cases at stake. Second aspect, guaranteeing access to justice to everyone while performing the balancing test. And third aspect, the openness of the courts to society, as well as the comprehensibility of judicial decisions. Dear colleagues and friends, now I turn to the first aspect, proper balancing duty of a judge. Justice is the foundation of the state under the rule of law. Access to justice is a key component on fair, human, effective, inclusive, and efficient justice, so all groups in society can equally enjoy their rights. According to the ideas of Western legal tradition, the judiciary is an indispensable guarantee of all constitutional rights and freedoms. Without access to justice and the effective judicial protection, the beautiful constitutional norms and principles would become only a solemn declaration, an illusion of the safeguard, a dead letter. The courts, transposing abstract values into legal rules, contribute to the fully fledged enjoyment of fundamental and innate rights that the national constitution confers on the people. The judicial decisions have a remarkable and immediate effect to the well-being of people. Therefore, the proper functioning of the independent and impartial courts is an essential element of any democratic state operating under the rule of law. Access to justice implicates, as stated many times by the European Court of Human Rights, the presence of an independent and impartial judiciary and the right to have a fair trial. The independence and impartiality of the judiciary are central to the public perception of justice and those to the achievement of the classical formula. justice must not only be done, it must also be seen to be done. And the judicial protection of democracy in general and of human rights in particular is a characteristic of most developing democracies. According to Reinhold Niebuhr, man's capacity for justice makes democracy possible, but man's inclination to injustice makes democracy necessary. The strength of the judicial power of the constitutional courts contributes to the solution of the question to which the politicians, representatives of the other two state power branches, do not have answers or do not wish to publicly provide them. While providing reasonable answers to the questions raised in cases, the judiciary, including and especially the constitutional courts, strengthens democracy, the rule of law, and educates society. And a good example illustrating this multiple role of the judiciary might be the ruling of the Constitutional Court of Lithuania of 9 December 1998 on the abolition of the death penalty in Lithuania. In this ruling, a firm and decisive position of the Constitutional Court, based on the extensive analysis of international law, was the catalyst for the reassessment of settled equilibrium of values. After a comprehensive analysis of the applicable international standards, the court concluded that the exceptional protection of the innate rights as provided for by Article 18 of the Lithuanian Constitution prevents the establishment of the death penalty in the sanction of the criminal code. The Constitutional Court stated, among others, that human life and dignity, as expressing the integrity and unique essence of the human being, are above law. They constitute a minimum, that starting point from which all other rights are developed and supplemented, and they constitute the values which are unquestionably recognized by international community. In such a case, the aim of the national constitution is to ensure the protection of these constitutional values. This landmark case in Lithuania has not only changed the legal system, but also, by bringing more protection to human dignity and fundamental rights, positively contributed to the changes of the legal thinking of the whole Lithuanian society, which was at that moment in favor of the death penalty. Likewise, in times of economic or other crisis or emergency situations, the courts are the last resort for people standing up against the decisions of the state power institution. When the worldwide economic crisis threatened the basis of the functioning of states in 2008, the governments adopted different austerity measures to ensure the collection of the state budget. In such circumstances, specifically the constitutional courts played an important role in defending people's constitutional right, including the right to the old age and pension on appropriate amount, the right to the protection of property, and the right to social benefits. The constitutional criteria in this area were established when balancing between the state's economic and financial interests and interests of people to receive fair payment for their work accomplished and fair amount of their old age pensions and other social benefits. Most importantly, the Constitutional Court of Lithuania in such cases decided to invoke the principle of proportionality as a leading principle in balancing public interest and individual interest involved in the cases. Such cases as, for example, concerning the reduced social benefits, the old age or state pensions, as well as the salaries of the state servants and other officials. Establishing a violation of the Constitution in such cases, Constitutional Court of Lithuania set up the clear obligation of the state authorities to adopt a fair compensation scheme for the unproportionate losses experienced by the population. And in all these cases, the principle of proportionality had played a very important role when balancing the interests involved in the cases. The principal role of the courts, and especially the constitutional courts, as the measure of the last resort in protecting fundamental rights, has clearly been seen in times of global COVID-19 pandemic. And this was also mentioned by President Laviņš when talking about Latvian cases in 2022. In numerous recent cases, the constitutional courts in Europe have recalled that the restrictions imposed on fundamental rights during the pandemic, regardless of the legitimate aim underlying these restrictions, can be introduced only in conformity with the requirements stemming from the Constitution. This principle has been clearly stated in the official doctrine of the Lithuanian Constitutional Court. If the necessity to introduce new measures facing the unprecedented coronavirus situation could be easily proven, the proportionality of such measures had to be properly evaluated by the national courts. Notwithstanding the fact whether the contested legal regulation was recognized as being in conformity with the Constitution, like in Lithuania, in the last ruling on 24 January 2023, very recent ruling, where the Constitutional Court assessed the legal regulation restricting the provisions of dental services and prohibiting the provision of beauty services in the spring of 2020, or whether a violation of the Constitution was established, like in Latvia, in the ruling of 10 March 2022, where the Constitutional Court assessed the prohibition on running shops not having a separate entrance, the clear message was sent to the society. Even in the extreme health situation threatening the health or the life of the population, the protection of fundamental rights and freedoms and the principle of the rule of law must be respected, and the proper balance between the public interests of society and the state on the one hand and the individuals on the other must be ensured. A prominent lawyer of Lithuanian origin and a former president of Israeli Supreme Court, Aharon Barak, stated that balancing is a very important tool in fulfilling the judicial role, as it expresses the complexity of the human being and complexity of human relations and introduces order into legal thought. Therefore, to find a proper balance between different interests is a daily function of every court. The court faces this duty in almost every case. For instance, in addition to my above-mentioned cases, inspired by different crisis situations, the Constitutional Court of Lithuania has dealt with search for fair equilibrium while defending the rights to ownership in the property restitution cases, where the proper balance was set up between the interest of the former owners of the property and its current possessors, or when the rights to ownership were restricted to the benefit of the state-protected areas. Moreover, in the constitutional justice cases, a balance between the national security interest and economic freedom was also evaluated, and the protection of private life of public person was opposed to the right to receive information, and the later right in the constitutional jurisprudence was recognized as prevailing because, according to the Constitutional Court, the media has the right to inform society about important details of the private life of politicians and the right of journalists not to disclose their sources unless a court orders otherwise. So, I am sure that there are many similar examples in the jurisprudence of the Latvian Constitutional Court, and some of them are closely related to those of my mentioned cases. And I think the President has also mentioned some cases concerning the protection of property rights. For example, in property restitution cases, the ruling of your court of 8 March 2006 about the termination of the maximum amount of rental payment in the nationalized housing property, and of course, where the clear balancing test and very clear balancing test was also ensured by the Constitutional Court. So, ladies and gentlemen, now I turn to my second aspect, the duty to guarantee access to justice to everyone. In society that acts by law and is subject to law, everyone must have access to justice. Every person, despite his or her gender, race, nationality, language, origin, social status, belief, or other grounds, may seek justice in the courts. The judiciary must respond to that demand without any prejudice or stereotypes prevailing in society. Article 29 of the Lithuanian Constitution lays down the principle of non-discrimination and the equality of people inter alia before the law and the courts. The Constitutional Court of Lithuania has clearly formed the fundamental principle that the Constitution is an anti-majoritarian act which protects everyone. This treatment of the Constitution as anti-majoritarian act was recalled, among others, in the ruling of 11 January 2019 on issuing a temporary residence permit in Lithuania to a foreign national in the event of family reunification when marriage or registered partnership act of the same-sex couples with a Lithuanian citizen was concluded in another state. The same viewpoint and at most the same wording might be found in the Latvian constitutional jurisprudence. In the ruling of 12 November 2020, where the legal norm that did not envisage the right to live in connection with the birth of a child to a female partner of the child's mother was reviewed. The Latvian Constitutional Court held in this case, I quote, "The stereotypes prevailing in society may not serve as constitutionally justifiable grounds for denying or restricting fundamental rights of a certain person or a group in democratic state governed by the rule of law." End of quote. This approach that the judiciary must act in cases without any prejudice or stereotypes prevailing in society was upheld also by supranational courts. Just a couple days ago, the European Court of Human Rights passed the judgment in the case Matsate versus Lithuania, which dealt with the situation in which the author of a children's literature book was sanctioned as she had published a book containing fairy tales, where in 2 fairy tales out of 6 relationships of the same-sex couples were depicted. Article 10 violation was established in this case. The European Court of Human Rights stated in the case that in a democratic state under the rule of law, the attitudes or stereotypes prevailing during a certain period of time among the majority of the members of society may not, on the basis of constitutionally important objectives, such as ensuring public order, serve as constitutionally justifiable grounds for discriminating against persons or for limiting their rights secured under the Constitution or Convention. The European Court of Human Rights acknowledged that the aim to protect minors from the particular information, in this case about the same-sex couples, based on those stereotypes cannot be seen as legitimate, as it reinforces the existing stigma and prejudice, which cannot be compatible with the notions of equality, pluralism, and tolerance inherent in the democratic society. And as you can see, Latvian Constitutional Court was in principle in the same line on argumentation concerning the stereotypes or prejudice in the society concerning one or another group of people. Therefore, this case and many other cases of the European Court of Human Rights and also the Court of Justice in Luxembourg have imposed a clear duty on the national courts to properly implement the constitutional principle of equality and non-discrimination. So, and this, my statement that justice should be accessible to everyone has also the opposite meaning. No one can escape justice in the modern state under the rule of law. Neither the official position nor the celebrity of a particular person can guarantee legal inviolability in cases of a breach of the law. Also, neither the constitutions nor the courts defend privileges. Democracy is incompatible with privileges. For instance, it was held by the Constitutional Court of Lithuania that the exceptional status of a member of parliament does not grant him or her any permission to disregard the standards of proper behavior towards his or her employees, and the failure to comply with these standards might lead to the impeachment proceedings and the loss of the parliamentarian mandate. This was stated in some impeachment cases in Lithuania against the parliamentarians. It was also confirmed that ministers are subject to the rules of legal responsibility that are not different from those applied to other persons, establishing, among others, the obligation of the ministers to compensate damage caused to the state while administrating the ministry. I must confess that today, in this solemn session, it's heartbreaking to speak about the task of the courts to bring justice to everyone in the context of the military aggression in Ukraine. And President Laviņš has already addressed this issue at large in his morning presentation. The unprecedented human rights violations and denial of human dignity due to the military aggression of Russia are being committed now in Ukrainian territory every day. We are witnessing shameless injustice towards Ukrainian people. Why do they have to suffer so much if they did nothing wrong? How are we all letting happen such brutality and denial of fundamental rights in the European continent in the 21st century? On this issue, I would like to remember once again the words of John Lewis I have already mentioned today in the beginning of my speech. If there are people hurting, people suffering, so we have an obligation, a mandate to do something. And now the question is addressed to all of us. What we, national, constitutional, or international judges, the parliamentarians, the diplomats, have to do in order to restore Ukrainian people's faith and confidence in law, democracy, and justice. I truly hope that my statement that no one can escape justice shows to all of us the clear direction for our actions. That those responsible for the military aggression and gross violations of fundamental rights in the neighboring independent state must be punished for their inhuman and disgraceful acts they have committed or are still committing every day in the territory of Ukraine. There is no other choice for us. I am rephrasing the words of Aharon Barak, because if justice fails in times of war, it will be unable to fulfill its role in times of peace and tranquility. And so here I would like also to thank to the President of the Latvian Constitutional Court and also to all justices for your support in trying to eliminate Russian Constitutional Court from our European Constitutional Court conference, because due to our common efforts, your court, our court, and Supreme Court of Estonia, we were able to reach the solutions that Russia is not anymore, not only among World Conference constitutional courts, but also European Conference on Constitutional Courts. And of course, our three Baltic State courts were the first initiators for this idea to eliminate Russian and Belarusian constitutional courts from the European Constitutional Courts platform. So thank you very much for this support. Excellencies, ladies and gentlemen, now I turn to my last point, the openness of courts to society, as well as the comprehensibility of judicial decisions. And here I will be short. People must have confidence in the judicial system, and we all know this very nice principle. Public confidence in courts is an important element of a democratic society under the rule of law and of an open, just, and harmonious civil society. These words are stated both in Lithuanian constitution, in the preamble, and in Latvian constitution as well. It is also an important condition for the effective activity of the judiciary. And now, the reflection is how to make it happen. Every judge of every court should contribute to strengthening the confidence of society in the judiciary. We are all united in the same objective, to advertise the rule of law, democracy, and the protection of fundamental rights. The strong judicial system is the cornerstone defending those constitutional values. Public confidence in courts is determined by various factors such as the qualification of judges, their professionalism, their ability to decide cases following not only laws but also law, the ensuring of the fair process of law, respect for persons participating in the proceedings, the rational legal argumentation, reasoning of the court's final act, the clarity of court's final act to persons participating in the case. The principal arm of judiciary in gaining confidence in it is the argumentation provided in the cases. The first big step in gaining the confidence in justice in Lithuania was the ruling of the Constitutional Court of 21st September 2006, where the court formed a clear obligation to all courts to draw up the entire final court's act with all the arguments thereof before the official publication of that judicial act. There's a requirement for the judicial decisions, such as non-ambiguity, the clearness, and the comprehensibility of the arguments and their choice, today already seem an axiom and not a theorem anymore. What remains is only their implementation in order to ensure the proper administration of justice. As it was stated more than once in numerous Lithuanian constitutional justice cases concerning the right to access to a court, the adoption of a just court decision constitutes a constitutional value. Justice delivered by court only in a perfunctory manner is not the justice that is consolidated, protected, and defended by the Constitution. And, most importantly, the courts must be open to society in all senses of this term. And President Laviņš has also mentioned some means or methods how this openness to society can be ensured by the Constitutional Court. Proper communication with the public might be the principal key that permits bringing justice closer to the people. The court should seek not only to deliver fair and reasonable judgments, but also should maintain fruitful dialogue with the people to whom justice is addressed. It is not an easy task. Judges, in principle, are not willing to speak loudly about their adopted cases or problems in the judiciary. This is Lithuanian tradition. I don't know how it's in Latvia. However, if we are not doing it, society will not understand us. And here I would like to refer to a very important case, Baka versus Hungary case by the European Court of Human Rights, where the European Court of Human Rights has clearly stated that leaders of judiciary, including judges, they have a right, they have also a freedom of expression under Article 10 of the Convention, and they have to speak loudly about problems in judiciary, because otherwise nobody would know about these problems. So then I invite all judges, especially Constitutional Court judges, to speak loudly about problems and also to comment your cases for society in order to better understand us and our argumentation. Dear friends, I am coming to the end of my speech. A former constitutional justice, Stasys Stačiokas, I think some of you maybe know him quite well, once said, "The greatness of the Lithuanian nation throughout the ages was not the force and cohesion, but wisdom in pursuit of prosperity and justice for all the people of Lithuania." With reference to the words of Mr. Stačiokas, and based on the wide recognition of the brotherhood and fraternity of our two Baltic nations, I wish all of us commitment, wisdom, and persistence in implementing justice in our daily work and bringing it to everyone. Your vocation can be found where your greatest joy meets the world's greatest need, said Frederick Buchner. Honorable ladies and gentlemen, thank you very much for your attention. Paldies par jūsų uzmanybų, novelų viso to labako, Latvija. Thank you very much.
I thank the President of the Constitutional Court of the Republic of Lithuania, Madam Jočienė, for her inspiring speech and also for her very kind wishes. Dear participants of the solemn hearing, on behalf of the Constitutional Court, I wish to express gratitude to the President of the Constitutional Court of the Republic of Lithuania, Madam Danutė Jočienė, for significant contribution to cooperation and reinforcing the cooperation between the constitutional courts of the Republic of Lithuania and Latvia, and for promoting judicial dialogue, for promoting justice and democracy. The Constitutional Court, in showing respect of these achievements, we present a certificate of excellence and for this very excellent professional knowledge and personal contribution, long-term contribution.
President, dear Danutė.
You can continue like
If I may continue in my language, I would say, visas satversmes tiesas vārdā.
Well, I would say, on behalf of the entire Constitutional Court, I am deeply honored to present to you the Certificate of Excellence for your contribution, for your achievements in reinforcing democracy, the rule of law, and for protecting human rights. And I wish, from the bottom of my heart, on behalf of our team, to express our gratitude for your friendship, for your support, and for reinforcing solidarity between the Supreme Courts of the Baltic States. We are currently already in such a nice stage of our trilateral relationships that we are always happy to meet our colleagues from the Supreme Court of Estonia and also Lithuania. Thank you very much.
Latvia. I haven't prepared any speech, but I like very much to speak without any preparation, because when I read it's not, I'm not so alive. So I understood in principle everything you said about our solidarity, about friendship, that in the name of the whole Constitutional Court you wish like all the best to me and so on and so. But what I wanted to say is that in principle, as I was talking about the challenges we are holding in constitutional justice cases, because I think we are in reality all of us on the same line when dealing with COVID cases, when dealing with stereotypes in society, European Court of Human Rights, Court of Justice in Luxembourg, Danutė Jočienė is here, former president of this court. So in principle, I think we all are capable of protecting in a proper way the fundamental rights and freedoms which are guaranteed by our national constitutions and international documents. But what is the most important? Not always we are in principle capable of having very nice and good relations between us as human beings. And really this I am sometimes missing, and your court, Latvian Constitutional Court, it's really very big exception. We are always finding very good cooperation, very good understanding of each other in every situation, when dealing with cases, when discussing topics for a conference, friendship towards Lithuanian Constitutional Court.
Cienījamie svinīgās
Dear participants of the solemn hearing, I would like to thank each and every one of you for attending this hearing of the Constitutional Court. I wish to you a pleasant day and a very successful new working year. I declare the solemn hearing of the Constitutional Court of the 3rd February 2023 as being closed.